So good afternoon, everyone. Thanks for joining again this afternoon. I'm Dazzle Abatis, Program Officer for Non-Timber Forest Products Exchange Program, Asia. And this afternoon will be the part 2 of our Forest Governance and Tenure Rights learning session, specifically on free, prior, and informed consent and safeguards. So from last time, we had an opportunity back in February to have a deep dive on what FPIC is all about, free, prior, and informed consent. Now we will have an opportunity to unpack and look critically some of the example cases on the ground, particularly in the countries of Cambodia, Indonesia, and Philippines. We will go to that later. But the focus now of this afternoon's learning session will be more on clinicking and learning from existing cases on the ground. Sophia, can you share the slides, please? Okay. Great. Thank you. So, and there are many more people logging in. So, Robin, can you kindly admit them as they come? So, just quickly, we have a 2.5-hour session this afternoon. So, just to show the overall program flow. So, we will start now in the introduction of the session and short review of what has happened or what was discussed during part 1 last February, and then we'll go straight to the plenary presentation of Cambodia case study. Then we do parallel breakout sessions. Later, we will discuss with you the mechanics, and then do a plenary discussion of what have transpired or learnings from the parallel breakout session. And then we will hear from Natalie and Edna on their feedback and inputs before we go to the final round of discussion and synthesis and closing. Next slide, please. So yeah, we will show you who are part of the learning session this afternoon. So later we will give a quick introduction, a short background overview of their work, but maybe Sophia can go to the next slide so we can show them who are we with this afternoon. So we have Isabel Shibig, James Lehman, from the Australian National University. They are both graduating students from ANU. Natalie Faure, thank you for the time. She's a senior program officer for RECOF, and Attorney Edna Magigad, also a regional researcher for CT and FPIC. You've met her already if you're here during the first part of the learning session. So, and next. And myself, Dazzle, and then Robin and Sophia, who's helping us at the back end, communications and knowledge management officer, and our program intern. Next slide. And of course, our executive director is here as well. So she will hear from her during the closing session. So the objectives, just to reiterate the objectives of the learning session this afternoon. So first is to present and share existing cases on FPIC and safeguards by indigenous people and local communities and other relevant partners, support groups in customary land or in forested landscapes. And second, to discuss and analyze and exchange strategies, meta-legal processes, and customary ways, even policy advocacy that can be developed and implemented by CSOs, private sector, and IPLCs on FPIC and safeguards in their respective areas of work. Next slide, please. So at the end of the session, we hope that we will be able to reflect on key elements or principles that need to be considered in integrating or applying FPIC based on the existing case studies that we will be studying this afternoon, and also develop and identify key strategies, targets for implementing and advocating FPIC and safeguards implementation that will be relevant to your areas of work. Okay. So I think that's it for the introduction. So allow me to share my screen, Sophia. One moment. I only have actually 2 slides. Because I'll go straight to the recap. Okay. So going straight to the recap, or what has been discussed by the group last February. So I only actually have 1 slide. So here are the highlights. Last February, Ms. Edna had a very comprehensive discussion on FPIC or FPIC 101. She called it FPIC 101. She was able to discuss, I put it in 10 bullet points or 10 key points. Policy origins, the FPIC development at the regional level. She also discussed what is free, prior, informed, and also she defined consent, FPIC monitoring, regional research findings, and benefits for applying FPIC, and challenges to FPIC implementation. So for policy origin, as a continuing discussion, she mentioned several policies relevant to FPIC, like the ILO Convention on 1989 or the ILO 169 that highlights the consultation that should be done in good faith, and also the Article 8J of the UNCBD that refers to the traditional knowledge, accessing traditional knowledge, genetic resources, but also emphasizing that it needs to be subject to free, prior, and informed consent to the holders of this knowledge. She also mentioned human rights-based approach to development, the Indigenous Peoples' Rights Act of 1997, and UNDRIP, elevating FPIC not just a moral obligation, but a legal statutory right, particularly the IPRA law in the Philippines, or the Indigenous Peoples' Rights Law. And then some of the policy origins also of FPIC is under the 2030 agenda. 73 out of the 169 targets have substantial links to the UN Declaration on the Rights of Indigenous People. In terms of FPIC development at the regional level, I think the main message there is there is still no concrete policy or regional framework specifically on FPIC, but there are existing policy frameworks, not really directly on FPIC, but are already in place that highlights customary tenure, social forestry, and ICCA. For instance, since 2012, the ASEAN Working Group on Social Forestry has been discussing FPIC as being pushed by the CSO, the Civil Society Organization Forum. But there are still mixed understanding of FPIC since then, and the FPIC still needs to be operational. In terms of regional guideline, existing guidelines such as the ASEAN guideline on promoting responsible investment in forestry, agricultural, and fishery sector, and ASEAN guideline in agroforestry development, has been emphasizing the free, prior, informed consent in this under these guidelines and in different principles within this guideline. Furthermore, we are at the moment also currently facilitating the process with the ASEAN Working Group on Social Forestry on the ASEAN guideline on on customary tenure recognition in forested landscapes. One of the principles there in the city guideline that we are facilitating is the right to free, prior, and informed consent. So she also discussed what is free. So free, the simplest term she used on this defining free is the absence of manipulation, coercion, and intimidation. And she gave, Ms. Edna also gave many guide questions when we want to extract or expound on the discussion on what is free. She also discussed what is prior, which means prior to any activity, and also gave guide questions on what can we use, questions that we can use to dig deeper to what prior means. Like, for example, when was the FPIC process conducted, or the chronology of the events, how much time was given to the committee to arrive at the decision regarding the proposed project. In terms of informed, she defined it as full disclosure of relevant information of the project. So this is informed, she mentioned also, as one of the most important part of the process. And usually civil society organizations who are here are supporting indigenous people and local communities on defining and contextualizing what relevant information is needed for the IPLCs to be informed. And lastly, for defining consent, Ms. Edna mentioned consent as a unique social contract. It's an obligation by one person to another, and it can be in various forms. Can be written, can be verbal, depends on the agreement. But usually, consent needs to be further defined because of its different notions. So parameters are needed to consider in defining consent. What else? She also discussed about benefits for applying FPIC. So one is to operationalize the principles of rights-based development, to have good practice that should be used in relation for investment, usually for private sector. And at the country level, the obligation is needed to be affirmed in the implementation of international policies, programs, and mechanisms. So sometimes when you apply FPIC, it gives you opportunity to access resources, gain capacity building support from different multilateral agencies or donors, among other things. So I think that's it for the highlights of what Edna shared. Also, there's still a lot to unpack. She also mentioned some regional research findings, but I'll go over time if I try to finish everything. But just quickly, she also discussed monitoring the challenges to FPIC implementation, and also the importance of having monitoring, FPIC monitoring, and also share some good and bad cases of FPIC based on her experience. So maybe I'll stop here and try to see if you have any questions or clarification so far. and we will try to address them later during the Q&A after the plenary presentation of James and Isabel. So if none, Kuya Roger, I'll park your question first. So going now to the plenary session, first plenary session, I'll introduce James and Isabel. So for the plenary, after the short review, we'll have now a chance to see different cases of FPIC implementation in several countries in ASEAN. So Isabel and James will help us with that. So to introduce Isabel, maybe you can flash again the slide, Sophia, of Isabel and James. So Isabel Shibig is a final year Bachelor of Laws and Bachelor of Development Studies student at the Australian National University. She is passionate about sustainability and human rights and is specializing in law reform, environmental and social justice. And then James is also a fourth year Bachelor of Laws and Bachelor of International Relations student at the Australian National University. He is passionate about Indigenous rights and environmental sustainability, and he is currently specializing in international law and governance. Maybe I'll already give the floor to Isabel and James. Take it away. Sophia will be sharing the screen for the presentation.
Hi, everyone. Thank you so much for having us today. It's a real privilege to be here. So before we start, I would just like to do a quick acknowledgement of country. So I'd like to acknowledge the traditional custodians of the land on which we're speaking to you from today, the Ngunnawal and the Ngambri peoples. So we're based in Canberra in Australia. I thank them for caring for this country for over 20,000 years and their continuing culture and contribution to this region. I would like to extend my acknowledgement and respects to the traditional custodians of the land on which each of you are living, learning and working from today. I pay my respects to elders past and present and to any First Nations people joining us today from across the globe.
Hey everyone, I'm James. Now, as Dazzle mentioned, we're going to start with a case study as a big group. And the idea here is to get across some examples of FPIC implementation or attempts at FPIC implementation, and then get some ideas of how other civil society organizations or other non-government organizations in general have been able to get some sort of outcome living in various different FPIC frameworks and regimes. So the first one that we're going to be doing all together is a case study on Cambodia, and specifically a rubber plantation that was attempted to be built by SOCFIN, which is a French company. So if we jump to the next slide, I'll give you some background. So so in Cambodia, there was a system of economic land concessions that saw parcels of land being handed out to companies for development. And this was a particular system developed by the Cambodian government, as they at the time were, and still are really, an emerging market that was seeing lots of growth. And in an effort to facilitate that economic growth, they wanted to kind of remove as many barriers as possible to foreign investment. And so these ELC concession parcels were often fraught with serious issues for the Indigenous peoples. So there was very little, if any, FPIC consideration. There was often just complete ignoring of Indigenous people and kind of appearing out of nowhere in the middle of the night to start to take down forests. And it's in this context that SOCFIN, which I mentioned was a French company, they intended to create a rubber plantation that was 11,964 hectares large, which is a considerable amount of land. And it actually made up 3 of these economic land concessions from the government that was initially held by a Cambodian company, but under pressure by the Cambodian government, that company sold them on to SOCFIN, as SOCFIN was a much bigger company and could pay a lot more. And then they took possession of that land. So on the next slide, I've got a bit of information about what Cambodia's specific national FPIC program was at the time. So Cambodia has not yet ratified the ILO Convention number 169, which I'm not sure if you've covered in your previous lessons, but just as a recap, that was one of the original binding international agreements that really enshrined FPIC as something to be pursued, and it included the process of free, prior, informed consent, but also made mention of, in the absence of free, prior, informed consent, providing compensation for those negatively affected by projects that went ahead without free, prior, informed consent. So that wasn't ratified, it wasn't approved and put into law in Cambodia. However, they did vote in favor of UNDRIP. But again, they've yet to codify those commitments into the law either. So there was no, legislated, strictly legal approval of UNDRIP and its commitments to FPIC. But the government did make a comment that in signing up for UNDRIP, the UNDRIP declaration, they were making a strong political commitment to the concept of FPIC. And so they since have developed a semi-formal FPIC regime that is not quite in line with what's required under international law, but has some sort of relevancy to the FPIC issue. So the Cambodian government in 2009 adopted the National Policy on the Development of Indigenous People, which had a specific aim to promote livelihoods of Indigenous people and improve their quality of life. And at the same time, they created the National Land Registration Policy, which under Sub-Decree 83 related procedures for land registration by Indigenous people and included some mention of free, prior, and informed consent protocols. And under this National Land Registration Policy, collective land titles were developed where the Indigenous community were officially recognized by the Ministry of Rural Development and then later approved to have these collective land titles handed out. They would be given some sort of ownership, an official recognition of their rights over the land. So 18 Indigenous communities in total received a collective land title as of 2017, I believe. And in line with that, 124 communities were officially recognized by that Ministry of Rural Development, and 111 were qualified as formal legal entities by the Ministry of Interior. In line with these policies, there were some areas of domestic law that required specifically impact assessment and consultation with only recognized Indigenous groups before development projects can proceed. So again, we're getting an idea that the FPIC regime that existed in Cambodia around the time of SOCFIN was not really meeting all the principles as required. So the next slide will cover a bit on the actual project in detail. So once SOCFIN acquired the ELCs to the some 12,000 hectares of land, they began their process of developing a rubber plantation. So they began by removing all the forests from that 12,000 hectares of land and excluding any and all Indigenous communities encountered in this process. So just a quick recap before we get onto the chronology of events. So far we have SOCFIN, which is the French company intending to use the land for their rubber plantation. And we have the Cambodian government who's seeking to facilitate SOCFIN's enjoyment of the land under their national laws for the benefit of the national economy. Now, not mentioned yet is the Bunong Indigenous community, which were the community most impacted by the SOCFIN land grab. So they were, of course, seeking to establish some sort of protection under either the international frameworks of FPIC or a Cambodian equivalent. And as we get to the next slide on the chronology of events, we'll see that unfortunately this wasn't the case initially. So in 2008, the forest clearance for the plantation begins, with the razing of the forest soon following. So they cleared all the trees and then set them on fire. And as this is happening, the Benong community begins to attempt opposing the project through protests and general activism. However, the government steps in to quash this, as they're again benefiting from the massive economic boost. Similarly, at this time, the Benong community begin to gather evidence of destroyed burial grounds and other sacred sites that are being desecrated in this 12,000 hectare region. And later on in 2008, the government continues to deny Benong community any consultation or subsequent compensation for the loss of their ancestral land. So returning back to, the ILO Convention of FPIC, which wasn't ratified in Cambodia, but still stands as a pretty good example of what FPIC might require. The government now is not only refusing to have any form of FPIC, but is also refusing to have any compensation provided for the loss that is being incurred. However, during this time, you also see a lot of civil society organizations stepping in to support the Benong and spread the message of what's going on across the world. And so in 2009, in response to protests and opposition, SOCFIN itself establishes a tripartite committee to find a solution that satisfies the Benong community. So the Cambodian government and SOCFIN are all hoping to get a nice win out of this. And so under this committee, there's a specific community liaison team appointed to oversee the provision of compensation, given the fact that past this point, we've already had the development taking place without any FPIC considerations. So on the next slide, we have a quick recap of what the issues were and then what the actions taken. So, to this point, we've had the forests destroyed, they've been razed, we've had indigenous communities displaced, and all this happening without any consent or consultation given to the indigenous communities. And we're also having all of this take place without any compensation given. So there is, and also, as I've got on the slide there, even though SOCFIN has appointed this liaison team that's supposedly working to secure this compensation, there is still very little actual compensation being given to those affected on the ground. However, after the fact, after all this has taken place, there was some successful actions taken. So we have some advocacy organizations and non-government organizations. They've come in to support the Benong community. And as I mentioned before, since the Cambodian government hadn't ratified any of the international instruments, there's not a lot of strictly legal international solutions that these organizations could come up with. So they generally relied on international soft laws in attempt to pressure the company itself to take greater action, rather than trying to compel the government or the company legally to do something. So as SOCFIN was a French company, of course, it sat outside the Cambodian law. However, these advocacy organizations had the foresight to attempt advocacy in Europe itself, so targeting the company in its home country. So European NGOs engaged in direct advocacy within Europe, which actually resulted in an investigation from the French-led International Federation for Human Rights. And this body had much greater say in Europe and France specifically, where French law could apply. And they eventually published a report finding that SOCFIN had violated the UN Global Compact and the UN Framework and Guiding Principles on Business and Human Rights, as well as OECD guidelines on how to operate in the area. So by 2017, French NGOs representing the Benong community were joined by other SOCFIN affected groups from Africa and Southeast Asia to directly lobby SOCFIN at its European headquarters. And this saw a collection of various advocacy groups from around the world coming together to really rally behind the findings of the French-based International Federation for Human Rights, and try and get SOCFIN to improve their track record. Since there's been some successful compensation claims, again, they're not completely we would say, adequate, I guess, for the type of displacement that took place. However, it is a step in the right direction on the part of SOCFIN and an example of how, you know, you can have an alternative method to kind of securing future FPIC provisions. And of course, coming along with a dedication to commitment is an almost prerequisite dedication on the behalf of SOCFIN, that next time, if they want to avoid the financial burden of providing compensation, that they'll be making a commitment to an FPIC process. And so that's really what happened in Cambodia. But just to give an idea of what we'll be going through in the breakout rooms in a bit more detail, if we hop over to the next slide, I've got a slide of the 4 questions that will be asked in the breakout room. And just being mindful of time, I might actually hold up on opening this out to the group just yet, and instead just give you kind of a few quick examples before jumping into the breakout rooms. So with the first question, you know, you might recall that there were attempts at FPIC principles, even though there was no clear demonstration. So we have the national policy on the development of Indigenous people and the national land registration policies. And these sought to fulfill the strong political commitment to FPIC without actually making a legal commitment. Whilst this is clearly a flawed approach, there is some attempt at gathering prior informed consent. However, the extent to which this informed consent was free or even informed in itself is quite questionable. You know, moving on to the next question, how did the community demonstrate their full participation? This is almost a trick question. You know, given that there was no clear FPIC guidelines in Cambodia, there wasn't really one of the any option for the Indigenous community to really demonstrate their participation in the FPIC process. You know, if they wanted to demonstrate their prior land use or their right to FPIC, then they certainly had gathered enough evidence in their photographs of the forest and desecration that took place. But this is really one of the major issues with FPIC that is coming across in this case study, is that given the lack of FPIC, there wasn't really an opportunity for the community to demonstrate this. And so looking at what remedies were present in this case, while there weren't any domestic recourses through the Cambodian government, the ability of the NGOs to rely on general political means in Europe to secure recourse was actually semi-successful. So being able to lobby the company and its customers to provide at least compensation for those affected, including seeking recourse through French-based international human rights bodies, really demonstrates, as I said, a sort of commitment to future FPIC treatment so that they can actually avoid that sort of financial penalty in the future. And then on the final question, and this is almost similar, for the CSOs and IPLCs, being able to sidestep domestic situations and rely on often large international networks of activists, you can sometimes take the action straight to the foreign companies in their home country and get a new way of effecting meaningful change without having to address or work within a sometimes lacking domestic system of FPIC. And so that's really all I have to say on Cambodia. I believe we'll be moving into our breakout rooms now, where Isabel and I will both be presenting separate case studies and going into these questions in a little bit more detail.
All right, thanks, James. Maybe before we go to the breakout session, let's see if there are some questions and clarifications from your presentation and also from the previous sharing of recap. So we have here Roger Garinga from IDS. He shared that international investors are vulnerable to international rules, but local companies in cahoot with government officials are difficult to engage to comply. What would be your reaction to this, James?
Yeah, that's definitely a really good point. And it's something that I think will hopefully come out a bit more when we get into the other case studies. But it is definitely a big issue with national companies that you can't really get to, you know, kind of outside of the internet, outside of the national system. You know, there's a few options that I'll get to in my case study, but just for the benefit of the whole group, you know, it is a really difficult situation. I kind of want to reiterate that, because if the company is truly completely national, then you've got to rely on the national system. But often you'll find with companies that are sort of big enough to be affecting this sort of land grabs that are supported by the government, is that somewhere along the way there'll be some sort of international intervention. So for example, in the case study I'll cover later in regards to Indonesia, there was a particular there was a number of national companies that were working within Indonesia to actually buy out land and then tear down national forests and sacred sites to plant oil palm. And what happened in that situation was that the civil society organizations and indigenous IPLCs were able to target the finances or any sort of international money coming into those national organizations. So in that particular case, you had a lender that was connected to the World Bank in some way. And so through that, the NGOs were able to make an appeal to the ombudsman of the World Bank and the International Finance Corporation, who were then able to make greater sort of moves towards altering the way that those national companies conducted themselves. Yeah, that's not really a complete answer to your question, because as I said, that's a really difficult situation, but that's sort of an idea of some other methods, if that's helpful.
Yeah, and maybe we can discuss more of that in the breakout later. Maybe one more before we go. This is for Miss Edna. uh, Roger is asking if this position emerged from the previous session. It becomes easier for moneyed companies to secure FPIC agency certification than smaller projects in situation where corruption exists. Is it valid observation? I think maybe you can weigh on this, Ms. Edna.
So when this international, hello, good afternoon, everyone. Thank you, Roger, for the question. So when international investors are operating here in the Philippines, they need to comply with or domestic rules as well. So the question is, if local companies in cahoots with government, a government official are difficult to engage to comply. So pretty much, I think this is a Philippine scenario, right? And we have the strongest legal framework for FPIC and a number of guidelines. It's actually a complete guidelines in terms from identifying who are the indigenous people who are required to get who are required to undergo the consent process. So here you're saying that if international investors partnering with local groups, whether that's government or companies, would also should comply with FPIC. Yes, they should comply. What if they are in cahoots with local companies? Well, they need to comply. If they will not comply, there are procedures under or existing laws wherein lack of FPIC is also a ground for closure of operation. Can be filed by the community or motu proprio automatically by another government agency in charge of the protection of rights of indigenous people, and that is called the National Commission on Indigenous People. However, how all these processes and what I call this redress mechanism when there is that co-optation happening, how accessible, how user friendly, that is another question. I hope I answered that. That's a very hard question. Thank you very much.
Thanks, Miss Edna. I hope it was sufficiently answered, Kuya Roger. So maybe now we go to the breakout group. So for the mechanics, oops.
Okay, so sorry. I got the I got the question kind of like I was confused with the question. Yes, there is that possibility that large corporation would have more chances of getting consent because of the resources they put into the process. And that's why it's very important to check on the aspect of free, whether that pouring of resources from large companies going into the process can constitute manipulation, bribery in the steps of FPIC. Thank you.
Thanks, Miss Edna. I think you can answer the question of Carlo also later in the chat, which is also a good question. But I think we're running out of time, so we can go now to, to the breakout session. I thank you for your questions. So Robin will be creating 2 breakout groups. So the first breakout group will focus on another case, the case of Indonesia, which is also what James is also sharing earlier. And then the second group will focus on the case of the Philippines, which Isabel will also be sharing. We'll have, I think, pretty much 30 minutes maximum for the presentation of case, and then maybe discussion on the guide questions that James presented earlier. So, Robin pre-assigned you already, or I believe randomly. So can we open the breakout groups now?
We didn't have anyone put their hand up. I think there were some internet issues. Most people were kind of responding in the chat. So I think we kind of said that I would just read out what our findings were based on what we wrote down. And so I think you'll probably see in our notes that most of our focus was on the last 2 questions. So in this Indonesia case study, as I mentioned, sort of before we went into our breakout rooms, this involved a situation where you had a large multinational lending group that were lending massive loans to local developers to develop palm oil plantations. And as a part of that, they often disregarded, or well, they completely disregarded Indigenous people and their rights. And so looking to what elements or principles of FPIC were present or absent, there were no real elements of FPIC observed. And even looking at absent elements in Indonesia, there's yet to be a recognition of Indigenous people and their rights at all. So FPIC being a subset of the right to self-determination in the rights of Indigenous people, there was no recognition of that at all. So the massive absent element was FPIC in itself, and more broadly, the legal recognition of Indigenous peoples and rights for Indigenous peoples. And, you know, sort of looking at that idea of no customary forests, you have these land that was recognized as customary to some extent by customary communities. But that land was dictated to be government land until 2012, when a constitutional court ruled that whilst those customary forests didn't necessarily take strict rights with them, those lands were no longer actually owned by the government. And so just hopping to the next question. Yeah, so how did the community demonstrate? Again, kind of mentioning what we said in the first part, there was a complete lack of an opportunity to demonstrate because there was no recognition of Indigenous people or their rights. So there was no consultation, no seeking of consent. There was no sort of inclusion of FPIC beforehand. But if we jump to the next slide, we'll see that even though there wasn't any formal FPIC beforehand, there've since been pretty strong developments in FPIC. So of course, because this system where they lacked Indigenous recognition or Indigenous land rights, there was no formal domestic recourse for the lack of FPIC, but there was significant creativity on the part of NGOs to protect the FPIC process moving forwards. So what we had there, as I mentioned, is international communities relying on the fact that the International Financial Corporation, who was providing loans to the Wilmar Group, was a sister company of the World Bank. And so by lobbying the World Bank and the International Finance Corporation to kind of abide by their own rules in handing out loans to the Wilmar Group and importing sort of those requirements of FPIC onto the Wilmar Group, you had some sort of FPIC guidelines being placed. And as it says on the slide there, though, there was still some disconnect between companies and communities in information dissemination. So the IFC would bring cases of FPIC that would be supported by the World Bank to make sure that FPIC and consent were met. But in this process, kind of FPIC was treated more of an afterthought. But in 2009, the World Bank accepted a moratorium that lasted 3 years. So they completely stopped all lending and spending on oil palm and instead took that time to think about their FPIC regimes and accepted a stronger definition of FPIC, more in line with UNDRIP and other international covenants that has since been the norm for dealings that relate to the World Bank and the IFC. Now, of course, this leaves the issue that we address again later, that not all sort of national organizations will be working with the World Bank and the IFC and their related sort of counterparts. But it's a pretty sort of significant step towards getting more global recognition of FPIC by these large World Bank, IFC, sort of UN level organizations that have significant sway nationally. And of course, the last point there are a few attempts at compensation for affected Indigenous peoples, but given the fact that the FPIC regime was coming outside of the country, beyond sort of ensuring that if a company wanted to work with the IFC and the World Bank again, they had to abide by future FPIC, there wasn't really much that could be done to secure compensation for those affected. And just moving to our last slide. Yeah, so what strategies can be drawn out? So specifically, and this is something I mentioned earlier, the NGOs targeted the finance of the companies. So the financing companies that kind of rely on this laissez-faire kind of lax FPIC regimes is a good way to look at getting these sorts of companies to stand in line with what's required of the international community. Here we also discussed formal recognition of Indigenous people and their rights in Indonesia, which is still lacking and still being worked towards. But the other point that we looked at as a more sort of minor point specific to Indonesia is that policies of customary communities and forests initially said that those lands belong to the state. However, the Constitutional Court in 2012 found that customary forests do not actually belong to the state. And so there's this endorsement of a legal formulation for customary communities and customary forests that has some sort of effect on land rights. And whilst this is yet to sort of be fully developed and fleshed out in the courts of Indonesia, it kind of represents an opportunity for NGOs and IPLCs and CSOs to look at pressing this point in the fact that there's kind of a vacuum of land rights. The state doesn't own it, customary communities have it, but that there's no land rights that are assigned to it, is a way for some CSOs to look at securing a form of FPIC through the process of customary communities and customary forests in Indonesia, rather than a strictly FPIC formulation like we see in international law. So yeah, that's kind of what we got to.
Thanks, James. Sounds like a very interesting and rather complicated discussion, but actually it's good that you were able to identify some strategies or maybe some entry points that our colleagues here can maybe try also in their countries, or also even us at the regional level can explore, no? So maybe thanks for that. We go now to the group 2. We haven't really identified also who will be presenting, but maybe I can ask Hong to present if he's still here. I can share the screen, Hong, for the notes if you want me to. Are you still here, Hong? He's still here, but he's still muted. Any volunteers from our group? One last call.
If you share the notes, Dazzle, I can have a go at recapping it all.
Yeah, that's okay. Maybe
unless anyone else.
Yeah, maybe Elaine, or who else is in my group? Elaine or Sweet, would you like to try?
That's all. I was not able to really focus on the discussion earlier, so I might pass. Thank you.
Okay, so maybe, all right. So for the interest of time, maybe Isabel can share.
Yep. Would you be able to share the slides, please? So for those, the case study was on the Iligan-Devilican Road in the northern Sierra Madre Natural Park, and so there wasn't a lot of FPIC processes. Would you be able to share the slide with the notes, Dazzle? Yeah. Perfect. Thank you. So on the first question, so what elements or principles are absent in the case? So at the end of the day, there wasn't enough consultation or broad representation from the communities. So what was shown as FPIC was a memorandum of agreement, and that was between the local government and there were only 14 ACTA male representatives. So it wasn't very representative of gender and geography, as 82 the road's 82 kilometers and covers a broad area, so there wasn't that sort of representation required. There also wasn't a lot of information given. There was sort of only the pros given to the communities, none of the not a lot of information about the negatives, such as relocation and all sorts of cultural impacts and things as well. Next slide, please, Dazzle. So because there wasn't sort of a lot of FPIC really present in sort of meaningful pre-prior informed consent in this instance. So we sort of discussed what communities could do to demonstrate the FPIC process. So We sort of discussed about conducting different meetings and lots of sort of organising within local communities and reaching out to local organisations. And so asking support from key organisations at sort of both institutional, local levels and national or even international levels. And then there was also discussion of so undergoing rituals, so ensuring things are done in align with the local community's, I guess, culture and understanding of what that FPIC process should be. Next slide, please. And then when we were discussing sort of remedies and sort of strategies, that those questions are sort of being linked. So there's discussion of sort of advocacy and following where the donor, so quite often the donors, they'll, whether if it's from a foreign entity or a development bank or something, they'll have procedures and things in line that mean FPIC is required. And so the Development Bank of the Philippines is the one who gave a big portion of the loan for the road development. And they had obligations of sort of, basically consultations with Indigenous people, and that because that didn't happen effectively, perhaps advocacy to them would be a good route to take. And also sort of documentation of the cultural significance of the areas, organisations, capacity building and acquiring the land sort of under the legal title as opposed to just sort of customary tenure ownership. And then the next slide, please. And then some of the other strategies we drew out was talking about securing the land for food security. That's a very important issue, and sort of expanding on explaining the pros and cons of projects, increasing capacity building, supporting communities in their lobbying and advocacy, and I already discussed the following the money concept, and ensure that in the consultation it's very representative of genders, particularly women, and everyone is able to participate and voice out the concerns. So that was, if anyone else has anything they want to pop in that I might have missed, please do. But I think...
Thank you, Isabel. I think there for our group there are lots of strategies also that we've learned from our participants also, aside from the case study, and especially the following the money, and of course it's very important to include ensure that all genders are able to participate in the process and voice out their concerns. So thanks for the two groups and thank you for the inputs of the participants. Maybe now we proceed with the critic and inputs to from our guest resource person. Maybe I'll start with Natalie. So to introduce Natalie, Natalie Faure is a legal advisor with 15 years of experience in forest governance, communities' rights, and policy reform in Africa and Southeast Asia. She worked with various non-governmental organizations and UN institutions on human rights and environmental issues. She currently works at RECOF, where she supports civil society makers to establish more inclusive decision-making processes on forests. Her current research and areas of interest include customary tenure recognition in the Mekong region and the role of civil society in forest governance. So Natalie Faure, sorry, there's two Natalies in the room. So Natalie, you have 10 minutes, sorry to cut the time. to 10 minutes. The floor is yours.
Great, thanks a lot, Dazzle. We had some very good discussion in the breakout group and also earlier with the presentations. So it's going to be less of a critique and more of like sharing maybe some thoughts on what I've heard and from my past experience as well. I think when we're looking at the application of FPIC, and it was also well explained by Edna earlier, that first we need to understand the concept of FPIC really well. That's an area that's still in discussion and often not necessarily well understood, both at national level, but by local actors as well. So there's already a lot of work that needs to be done around unpacking the concepts and what does it mean? What does FPIC mean in general terms? But also more importantly, what does it mean in practice? So how do you apply it in a specific context? It has to be adapted, of course, to the community and to the actors in presence. So I think one of the aspects that came out of the discussion is the fact that you have to look at the actors and the forces, the interests that are present. One point which I found quite interesting that was made earlier is the distinction between national, local, private sector actors that might come in and want to use the land of a community versus an international actor. And that matters because the resources and the remedies that you might have later on, if there are violation of the FPIC process, will be quite different. So the common element from what we've heard in terms of the cases that we've looked at is always a change in the use of the land and pressure from outside stakeholders on the community. Now, if we are looking at how to, I guess, prevent or address the violations in terms of the application of FPIC, we can look at it in two ways. So on the ground, in specific cases where violation has happened, we discussed about looking at remedies and making sure that we look at all of the possible ways of using those remedies. So investments, international instruments, as we discussed before, such as UNDRIP, ILO 169, and so on, but also using national laws, contracts, possibly as well. There might be contracts between the community and a private company or outside contracts that might be able to be used. Advocacy and lobbying, such as towards the World Bank, as we also heard before. But also in specific cases, providing support to the communities. So some important points that were made also in our group was making sure that there is some support that is brought to the community for them to also organize themselves in some kind of association or strengthen their own community organization to be able to act. There also can be some legal awareness and other skills building processes that can be brought. In terms of prevention on the ground, we also mentioned training. So being proactive as, for example, CSOs to secure the lands of communities. Explain FPIC, what is the concept? So going back to trying to unpack what that means. But also providing information on the project ahead of time from the side of CSOs as well. So that's something that can be done to prevent FPIC violation. And communities documenting the cultural value of the land was also an aspect that is quite important and was mentioned. So after looking at on the ground, we can also look at the national level, what can be done to secure and to I guess, remedy FPIC violations. So use the laws creatively, identify which laws can be used to support FPIC, even where FPIC is not fully recognized as such in the law. So there might be some mechanisms that can be used, some legal provisions that can be used to support the consent process. And then another aspect I also wanted to bring is the work on legal reforms. So that's something that we've heard as well. It's important to integrate FPIC in national laws. And the Philippines is a good example in terms of having quite a fully recognized legal framework, but there are still some challenges to apply it on the ground. So having some clear guidelines as well that are culturally sensitive and develop an understanding of what FPIC is and can be adapted to a specific community and a specific situation is really important. The last two aspects I wanted to bring, one is the importance of taking into account gender and including various members of the communities when carrying out an FPIC process. So we've been talking about FPIC, but thinking also about how this can be done, the FPIC process can be done in a way which respects the community practices as well, while also recognizing that there might also be some unequal power balances within the community as well. So that's something that there is no one answer on that, but it needs to be considered as well. And maybe the last point to bring would be recognizing that the FPIC process takes time, and often these development projects are time bound. But also thinking of FPIC in the sense of an iterative process, where you get the consent of the community before the development project is taking place, but also alongside the project. So the project might take a few years, it might take different ways. And so I think it's also useful to think of FPIC as a process within the timeline of the development project as well. I think I will stop here for the food for thoughts. I hope that was useful to continue the discussions. Thank you.
Thank you so much, Natalie. Actually, those sharings like a summary of what the group, the second group was also discussing earlier, and coming from the learning from the Philippine experience. And also, thank you for sharing the importance of looking into the actors and the importance of dissecting which type of actors are we, or the IPLCs needs to engage in terms of FPIC, and the different types of remedies that we can use, and also that we can help indigenous people and local communities, for instance, in terms of capacity building, advocacy and lobby, strengthening their community organization, and what avenues or entry points can civil society organizations like us can help or facilitate or work together with the IPLC that needs support in reviewing laws, and how can we be creative in looking into possible specific mechanisms or legal provisions already in place at the national level, and also the importance of gender in carrying out the FPIC process. So thank you so much, and also thank you for sticking to the time. And I think you've done it in less than 10 minutes, so we appreciate that. So next resource speaker, and also to provide critique and input is Attorney Edna Magigad. Attorney Edna is a developmental lawyer for almost 20 years, working on environmental governance, climate change, and IP rights. She's currently helping us as a CT and FPIC researcher for the Mekong Regional Land Governance Project of NTFP-EP, and also currently leading a project on community biodiversity, natural climate solutions in Palawan, Philippines, with the Conservation International Philippines. So Ms. Edna, you have 10 minutes for the critique and inputs, and then 5 minutes for the wrap up of the learning session. So the floor is yours.
Thank you, Dazzle. Thank you all. And yeah, Natalie, thank you for that. And I will just add on to what Natalie has emphasized. And yes, recognizing that there are many FPIC processes already ongoing in the world and in Southeast Asia. But if we really unpack these cases like we did today in just 3 cases, we see that there is kind of already a doubtful interpretation of how they stick to the elements of FPIC, and if it was indeed free and it was indeed prior and informed. That is why it's very important for us to have this kind of learning session, to have this kind of unpacking of case studies, and as a group of CSO pushing, advocating for FPIC, have a continuing assessment of all these FPIC processes. But I also wanted to emphasize that the importance of monitoring the agreements that have happened on the ground, whether that is with a big company, with government, across Southeast Asia. So when we have this kind of issues of doubtful agreements, though the importance of having a grievance mechanism is now more important than ever. So if you look at the case study, where it's actually very good in terms of like compliance with national law, compliance with international safeguards like IFC, and you have these big standards of RSP of big corporations. But if you want to be practical about its implication to community, you now have a problem of implementation. And now is the start for a next phase. If you have this consent that is vitiated, manipulated, and really not informed, then monitoring that implementation and ensuring that communities know that FPIC is the right to say yes or no, the right to withhold the yes, and it's an iterative and continuing process. Therefore, dispute mechanism is now a very important aspect. Okay, so we should look then, my second point when I was looking at the different case studies, and actually is that in the case of the Philippines, as well as in the case of Indonesia, we were looking at the case studies sort of like FPIC as a standalone process, but we know that FPIC builds on existing mechanism, institutions on the ground, as also explained by Natalie. You have power dynamics, you have capacity, awareness, the level, capacity of indigenous people to understand their rights, as well as the NGO supporting them. So I wanted to emphasize as well that, okay, so FPIC should be, or work pushing for FPIC and understanding FPIC should also consider a number of aspects. So I listed them while I was listening. First is that legal reform, yes, and then recognition of the identity of this indigenous people, and comes with recognition is this right of FPIC as a subset of the right to self-determination, as well as a subset also as a good business case for a standard for corporation. It's very important to have this legal recognition placed either at the constitution, just like the jurisprudence in Indonesia, wherein there is no specific explicit policy, but you have the constitutional court decision in 2012, vis-a-vis the Philippine case, where you have that an Indigenous Peoples' Rights Act, but the understanding of how FPIC is actually implemented on the ground is problematic after 20 years of FPIC guidelines or 6 FPIC guidelines. So very important that the recognition is full recognition as to the rights of indigenous people, as to the identity. Who are these indigenous people who have the right to claim FPIC? When we say a recognition, it also goes to what particular chunk of area they're being recognized. When you say claim, the claim should be documented as we are entering processes, formal processes with corporation, with government. So the claim should be documented, or this rights to a particular chunk of land is documented in terms of paper. Is it a claim? Is it a title? Or is just native title? Because most FPIC process would also need support. Who are the people and what is the extent of their claim? Hence, in my work now, I make sure that these are backed by spatial imagery delineated by indigenous people, or community 3D mapping. So these are your area, these are the land, these are the resources, and these are the possible impacts of this development project seeking consent. So important that they have awareness of their territory, their rights to that territory, and that is distinct, and they can really delineate their territory vis-a-vis another group of indigenous people or other community group, or vis-a-vis other group. The third aspect is best if, of course, we support this evidence towards that, because as FPIC process, there's also some kind of like a documentation, whether that documentation is formal, informal. Now we see that we need it to be written, not just oral. So there's a need to support community into putting that into some form of writing and documentation. Okay. And then what I've emphasized that jumping from my experience that I've handled FPIC processes as both an applicant, as advisor, as also leading some project like 15 to 20 FPIC processes. And it's kind of really challenging, even though we know what should be done. So I would emphasize the importance of the grievance mechanism. And here we have to unpack. When you say grievance mechanism attached to an FPIC process, is that this is, of course, zeroing on the applicability of customary law as the primary law. And this should be that the escalation process, if there is failure of customary law or absent of that, we should know, and the community should know, that this can be elevated into informal or formal or state laws. The accessibility of this mechanism with the timeline that the decisions would be at this point, and user-friendly, understanding the process with flow chart. And of course, what kind, this should be, we try to get out of the formal system where communities would have to pay fees, where you would have lawyers, which are expensive, as well as processes that are bureaucratic. So we push for alternative dispute resolution, whether that's negotiation, conciliation, or arbitration. So we have that already being discussed. Okay. So so these are just some of the thoughts, but my last few thoughts would be on going back to the foundational aspect of FPIC as we try to understand it, as it is applied to across Southeast Asia, is while there is no national law in some aspect, and there are many standards that are and then FPIC is also part of ESR of companies as well as of institutions, just like development organization. I just want to be clarified, and that there are like 5 items that we also need to know and understand as we go on with our study or continuing assessment of FPIC. One, who is seeking consent, and we have to unpack it. Who is seeking consent? When government is the one seeking consent, if government is with partnership with projects like ADB, World Bank, or even USAID and all this, and what is the process? Now, do you have you have UNDRIP? If you don't have a law, national law, you have UNDRIP that says that there are Article 22 that the government would have the responsibility to consult and cooperate with indigenous people when all these development projects are coming in. But when it is second, when it's corporation or private sector, now you have a different kind of FPIC processes or standards. So, and then we have to unpack that, whether large, small, or medium scale corporation, and in what sector, agri, forestry. And then third is when these are CSOs or NGOs also going into indigenous territories with their projects, so getting consent. And if this NGO partners with number 1, the government. And the fourth one is these are when other communities are also getting the FPIC of an indigenous community who has now rights, recognized rights. And so this is happening in social forestry area, where we're now with the reforms ongoing in Southeast Asia, where indigenous people are actually recognized and given titles to certain areas, and you have existing community who have been there for some time. So how they arrive at a benefit sharing agreement, and that would also involve a consent process. Okay, now going on to the second aspect is that what is the process for seeking this FPIC? And the process sometimes depend on the first one, the who is seeking consent. But important in the process, who is facilitating this process? Are they also aware? Are they using rights-based approaches? Who monitors up to its implementation? And up to the grievance mechanism, and up to the fruition of the different benefits that was already there. Okay. Very important to be worried about project developer who set up their own process because the community is weak or the community has no FPIC, own customary FPIC process. So we have to also distinguish this as the process that we know of in terms of the standard, the national process, into a third aspect, the actual consent seeking process in the community. That is different, that is beyond us, that is really internal governance processes. And we should help them build their capacity of traditional governance, how they would understand the customary law governing their own territories. That would include consent. In this consent-seeking process, who has the right to give consent to the third party seeking clearance? Is it the elders only? Is it the entire community? Are women involved? Is it the leadership? What is the extent of the discussion? Would that involve all groups, just some groups? So I've met with different kinds of community decision-making processes. But important to note that there will be instances, and this is happening a lot. Parts of the community may support that project. Some of the community mates might support or against the project. So there is now the opportunity for bribery, and some even government who was facilitating it would build new organization just to make sure it will facilitate a yes. Also important that when you are looking at the internal processes, we should also be watchful that the impacts of this project are not uniform across the community. So there should be stronger voices for community who are more impacted. So now when we say impact, so now going on to my third aspect, information needed for the community to really have a good and informed decision that is prior to any decision-making process. So the information in terms of knowing, okay, my experience is the community also needs help in knowing what information is required to be there in their environmental impact assessment. How would they analyze that? How do they demand that it will be in a language that they understand? How is this information translated to their actual way of looking at their impacts? Because this is how they decide. Because women are also affected differently. And now I go to my fourth point. Now, if you look at UNDRIP, we're looking at FPIC because it is needed because there will be displacement, relocation, impacts to cultural heritage. Therefore, there is compensation and there is relocation. But I'm seeing now in the field, and I think in parts of other parts of the world as well, is that we are actually progressing. When we say the impact of FPIC, we're looking at how it impacts traditional occupation, how it impacts not only cultural heritage, but that intangible cultural heritage, that loss of identity, how will it impact the right of women, the right of children, the loss of traditional way, the loss of livelihood. We are now looking for well-being. It's not just benefit, but really the right of survival and benefit. When we're looking at land relocation, we're not on land alone. We're looking, I've seen FPIC for land for mining. Eventually after 5 years, you have diarrhea because of water pollution. You now have loss of cultural and spiritual life. So the impact goes beyond land resources that are tangible. We are now going into pollution. We're now going into derivative impacts. We're now going into the youth, knowing different land, and now we're going into intangible heritage. And then I would end there. I have other things, but I think I am over time. thank you very much. And that is just a snapshot of my thoughts for this session. Thank you very much.
Thank you, Miss Edna. I think you still have you stick to the time. Almost over time, but thank you for sticking to the time, and thank you for that very comprehensive um, sharing of your critique and inputs. Um, I will not go over to all those sharing, but yeah, just to emphasize what Ms. Edna has shared is the continuing assessment of EPIC process and the importance of monitoring the agreements, and the importance also to push for legal recognition of the identity of IPLCs, and to look into, and you also raised so many questions also again, like guide questions for CSOs and IPLCs to look into and check how IFPIC is implemented on the ground, and in terms of recognition, in which particular area, and you also shared some tools like spatial imagery and 3D mapping, integrating, using, working with communities in their community maps, and try to integrate or use technology like GIS for spatial mapping and 3D mapping, and to also try to help in delineating their territories. And you also emphasize the need for the community, the support needed by the community to really document their evidence towards the full FPIC process. Yeah, so maybe I'll stop there and open the floor for some questions, clarifications, or reflections from the discussion this afternoon. Yeah, you can now raise your hand for some questions or maybe reflections or learning. Yes, Ma'am Chai, go ahead.
Yeah, as a wrap up, I also message this to Edna. Like in the case of Kitanglad, for the FPIC, it's not just about dealing with community leaders, the traditional leaders, but also for those with strong spiritual culture, they also speak the rights of resources protected by nature spirits. So this is a quite, I would say, a rare case for now. And I even suggested how this kind of experience in FPIC, wherein the invisible elements and their rights are included. In Ecuador, the Constitution recognized the rights of nature. Here in the Philippines, in Kitanglad case, they also highlight the rights of nature spirits to dwell, coexist in good coexistence with human beings, with the same responsibility to protect nature and all its elements. So considering this is a rare case, and I would say like there's still remaining threats of pineapple plantations, road development, and it's not just really about the legal compliance and FPIC, but really understanding the spiritual sensibilities of the tribe. And are we ready for this to really like also unlearn? Because as said, there are policies that we use to fence, to defend communities, but at the same time, do we also grapple or understand spiritual culture, because it's quite strong to some areas here in Kitanglad. So it's a struggle because, like, for instance, the government, if there's no paper, there's no something of legal instrument, they don't recognize indigenous peoples, right? This despite IPRA. That's why some of the recourse is to register the CADT, but these are actually external rights, but not the deeper spiritual rights. So this is a challenge for all of us, that there are realities like this, and we have to make sure that we also include this in safeguarding the strong traditional spiritual culture of indigenous people.
Thank you, Ms. Chai. That's a good reminder that to also don't forget the invisible elements, the spiritual, the cultural rights of indigenous people, apart from, of course, the legal rights, the statutory rights. Um, Thank you for sharing that and emphasizing that. Um, any more reflections and questions before I go to Nathalie's question? From our colleagues from Indonesia. Carlo, any reflections or thoughts after the discussion, the breakout session, and sharing of inputs from Natalie and Edna? Carlo, and then Pham Hua? Or who else is here? Vanida and Sufalin from Week of TC Laos. Any reflection or thoughts?
Yes, thank you, Daso. It's a good opportunity for me to learn from the regional and Indonesia and Philippine case. For Laos, we it's not so complicated, but we have like a new regulation that can be applied for the APIC and can be support the FPIC process. But as Natalie also mentioned, that is quite challenge to especially for our country to apply those new law in the local community, and also to make it eligible and understandable for all the local governance and also the community that's still some and also some of the law still conflict and overlap each others. Yes.
Thank you, Safalin, for sharing. Yeah, and there are new lots of developments, policy developments in Lao at the moment. And there's a challenge also, in translating these new laws in implementing on the ground. Any other thoughts or suggestions or reflection from this afternoon's sharing? Hong from Vietnam, or Hoa Pham?
Yeah, I do think it's a very good presentation, and also sharing today. In previous section and today talking. For me, it's fine. That's all I know.
Yes. Any takeaway from this afternoon?
Yeah. Then takeaway. I think I have a chance. I had a lot of chance to do FPIC in our country. Also, from small cases or big cases, for land grab or in a simple case like a negotiate between the foreign user and foreign company. For instance, about that, they apply the FPIC. It's a very good way to maintain or ensures the benefits for the different groups. So in this afternoon, I think it's quite clear. It's quite clear the process and experiences from speaker. That's I do think that's very so useful knowledge for me to and also my colleagues to apply and to develop and in our country.
All right. Thank you, Hong, for the recognition and also for sharing that you learned something new that you can apply. We acknowledge that you're already an FPIC practitioner in Vietnam, but thank you for sharing that you've still learned something. So we are running out of time. So apologies for that. We can go to a quick wrap up from Edna. Sorry, Natalie has a question, Miss Edna, on what tools have been used to obtain FPIC in cases where internal community governance may not be fully equitable. Maybe Miss Edna can answer, or maybe others can also weigh in.
For that particular situation, what is usually being done is that really support leaders within that groups to first is to mentor them on certain equity, to rights based. So it's also identifying leaders who can be champions of equity. But before that, we also need to know, as someone who was outside of that system, is that what is their notion of equity, because we have a different notion of equity, and each indigenous community would have a different notion of equity. So we have to treat equity as a new concept, and then we have to unpack it and understand it from where they're coming from. So we provide them the support in terms of understanding dialogues among them. Sometimes they would need resources to pull traditional leaders together, or just a venue to talk, or even just a venue like a traditional hut, or so that is, so providing them all these platforms, physical and supporting for them to discuss. And it's a long process, Natalie, and it depends per community. And then after that, so tools, and then draw up an agreement or draw up our rules, their internal rules. Sometimes they would come up with their internal protocol, and if they still has not put that into writing, that's another tool that is being used.
Okay. Thank you, Miss Edna. Thanks. I hope it answered. Miss Edna answered your question, Natalie. Okay, so we're already in 5:30. And maybe just to go back to, may I request Ms. Edna for a quick wrap up of the session. 3 minutes quick wrap up, Ms. Edna, and then I'll call Ms. Femi for the closing.
Yeah, for this, I wanted to emphasize that we are all, I think, knowledgeable on the concept of FPIC, and we try to actually learn more about it. But now it just struck me that we need to also have an assessment of ongoing FPIC processes in the region in terms of best practices. I think we have done that, but good to have that in a more formalized way of getting an example of the different agreements. And then if we can have a sample from different community, what agreement can best highlight these principles and then concept that we are talking about. And Natalie has emphasized that we have to be creative in the use of law. And I would like to add, we have to be creative and practical in the use of law. It doesn't have to be within the realm of the legal system, of the policy, but of course consistent with customary law. But we can engage in many aspects like meta legal tactics, advocacy tactics, and all that. So, and I think next I would like to emphasize what Shai here has mentioned of also consent process with the spirits. That has been also an area that is kind of not missing but not emphasized, and it's some communities are losing that because of sometimes government imposed regulation before. When they vote in one community, they would vote using certain leaves. If the bitter leaves would be no, the sweet leaves would be yes. Or sometimes different fruits. That's how they vote. And it's with a ritual. Now, it's now viva voce or raising their hand. And that is not within their culture. It was just facilitated by what? Of us, of people who want to document or bureaucratize the process. So in that process, we are losing some essence, which is the spiritual essence, and that they evolve in a different worldview. It's not only concrete land and resources, but the spiritual aspect as well. So the rituals, it's different rituals. I've witnessed different rituals, and we try not to think more about it, because sometimes it's like, if that particular ritual, which is if this falls, if this particular instrument would fall when it is put in a forest area after several days, then it's a no. And then what if there's like big rain and all that? So we try not to be what we call this, use our own concepts into this concept. But yes, it's important to also not lose sight that the integrity of these territories also involve the spiritual aspect and the intangible cultural heritage as well. And that is linked to, of course, livelihood. So these are just two main points, Dazzle, that I want to emphasize, because the rest have been pretty much discussed already. And thank you very much. And thank you for listening to us. And always a pleasure to share whatever I can share. Anna. Okay. Thank you very much.
Thank you, Ms. Edna, and we are very much thankful for your presence and inputs here, and also with, as well as Natalie's inputs and critique earlier. Very, very useful. Now, just for the closing, I would like to call on our Executive Director for NTFP-EP Asia, Ms. Femi Pinto. Ms. Femi, the virtual floor is yours.
Thank you, Dazzle, and thank you to Edna. Actually, I didn't want to follow that anymore because basically Edna already had summed up, and I think we also got some very good kind of summing up reflections as well from Natalie and all. But just to say that our learning session is also going to be a product that will contribute to a next step, which is for one of our projects that's also supporting for this learning session. Why it has happened is because we're also in a project that is supported by two ongoing programs. One is the Mekong Regional Land Governance Project, and then there's also the Green Livelihoods Alliance. So there's some continuing work that are also from local all the way to policy level. And one of the concrete outputs that or knowledge product, if you can call it that as well, in the coming months would be an FPIC handbook, which would be more like a dedicated or targeted for stakeholder group, not necessarily the community, but some government players that might also find some use for having guidance on how they could be protectors or champions or facilitators of FPIC processes in the course of their work in the forestry sector. I just wanted to, this is just a very quick kind of a burst of conceptualization and visualization of what has happened or what has been discussed today and how to place them visually. And so I just wanted to sum up, moving forward, there are actions that we all can take. One is from the community level. We have some leaders here who have also given us advice and recommendations on what they carry out. But then most of us are also from the civil society organizations that can also help facilitate and advocate for strengthening of FPIC processes and enforcement of them, and where there is not yet a strong framework that we can continue with the work. So basically, just summed it all up, moving forward, the things that we see or we can take action upon would be at 3 levels. The very first one, or the top one, or you could say the bottom up, however way you want to view the visualization, is at the community level. We heard that there's a lot of mobilization that needs to happen, organizing, dialogue. Edna had mentioned that. And essentially, this is really to make sure and ensure that the culture, practices, beliefs, and aspirations of communities are secured, and they have the governance mechanisms and structures intact in terms of facilitating the FPIC process. But in the middle part, there are us, most of us who are at the civil society organization, where we act as interlocutors or intermediaries, and our interventions could be at the level of capacity building on rights and policy, understanding of rights and policy frameworks, facilitating learning sessions like this, and also facilitating discussions to analyze, monitor, assess how well FPIC is being carried out, not carried out, and if there are remedies that we can also facilitate or mediate for and on behalf of the communities. But the last level of work would be at the policy advocacy level, where Natalie had mentioned about towards what. So it's basically towards reform of policies, initiating certain policy measures or frameworks. And then if there are already some good policies that we ensure, we advocate, we do advocacy to ensure that there's effective enforcement of them. On the right side, there's a pillar there on monitoring and assessment, which I think was one of the value added of our discussions, is a lot of emphasis on this, on carrying out and learning the tools, applying the tools, and even getting some guidance and steps on how to do monitoring and assessment, which I think would be of good value for us, for NTFP-EP, as we facilitate the development of a handbook in the coming months. But the most important of all, at the bottom of this, the foundation of FPIC, would be the understanding and assurance and security of the rights, culture, and well-being. And the last aspect that I heard from Edna that she injected was about impacts, the assessment of impacts of projects, and the implication of FPIC goes beyond the now, but there's also the later on aspects that has to also be taken into account in the assessment of FPIC. In terms of impacts on environment, etc., I would also just include that in the rights framework. So I hope that contributes something. I hope that we can also use this later on in our development of our content for the handbook, and we thank you so much for adding also to that process, and to both our new colleagues, Isabel and James, also for starting off with some case studies, and they're also continuing with some research. They have only just picked 3 out of, I think, already a number of case studies that they have now collected. So thank you, and I hope that we see you again in the next learning session